Greetings to everyone. Hope everyone is in pink of their health. This side Suyash Tripathi, my second year student pursuing BLLB honors from MIT Law School, Gwalior, Madhya Pradesh, and currently I am working as a legal intern with LEXIS and Company. So today we are going to discuss the Article 13 of Indian Constitution. So the Article 13 deals with the law inconsistent with or in derogation of the fundamental rights. So what are fundamental rights? Fundamental rights are those rights without which the survival of an individual is almost impossible. So the definition is given in the Article 12 that in this part, unless the content of the state includes the government and parliament of India, the government and the legislature of each of the state or local authorities within the territory of India or in under the control of government of India. So Article 12 of Indian Constitution defines the state and the government. So the state and government as defined by the Article 12 cannot make the laws inconsistent with or in derogation of the fundamental rights according to Article 13. So the clause 1 of Article 13 says all laws in force in the territory of India immediately before the commencement of this constitution, insofar as they are consistent with the provision of this part, shall to the extent of such inconsistency be void. So Article 13 first clause says that all laws which are made in the which are in force in the territory of India immediately after the commencement of this constitution. So after the constitution came into force, or after the commencement of the constitution will become void, or if they are inconsistent with the part third of the constitution. Part third deals with the fundamental rights. So if any law is ultra-wise to the fundamental rights or the ultra-wise to the part third of the constitution, it will become inconsistent and will lose its effect in the territory of India. So clause 2 says the state shall not make any law which takes away or abridges the right conferred by the part, and any law made in the contravention of this clause shall to the extent of this contravention be void. So the clause 1 was saying that the laws which were already there and after the commencement of the constitution they will be void, but the clause 2 says that after the commencement of the constitution the state shall not make the laws which are in the contravention of the Article 13 of the Indian Constitution, that is which are in abrogation of the which are inconsistent with the fundamental rights of the part third of the constitution. Clause 3 says, in this article, unless the context otherwise requires law, subclause 8 says that law includes any ordinance, order, bylaw, rule, obligation, notification, custom or uses having in territory of India the force of law. So here the definition of law has been given, that what all is included in the law. So what all cannot be cannot infringe the fundamental rights. So this subclause has a very great effect and had been an issue with the had been a part of the issue or the topic of the issue with the between the Supreme Court and the Parliament in the late 19th century too, as the constitutional amendments are not given under the definition of law, and the parliament has been making the amendments in the constitution which are against or which are infringing our fundamental rights. So the parliament always contended in the court that the Article 13 was saying just that the law the law as defined doesn't contain the amendment as a part, so we can make amendments. But the Supreme Court said that the amendment in the case 1 and Bharti case, that amendment can be made in the constitution and the amendments are the part of law as well. So law in force includes clause B subclause B says that law in force includes law passed or made by the legislature or other competent authority in the territory of India before the commencement of this and not previously repealed, notwithstanding the law such or part therefore may be in operation. So and nothing in this article shall apply to the amendment of the constitution made under Article 368. So nothing in this means the amendments can change the base amendments are the laws, but they can restrict our fundamental rights to some extent, but can't change the basic structure of the constitution as defined in the case 1 and then Bharti case. So this was all for today. If you have any doubt, do comment in the comment box, and don't forget to press the bell icon and click on the subscription button. Thank you.